So the mandatory considerations for reportable conduct allegations: a standard of proof on balance of probability, and that needs teasing out, professional standards, codes of conduct, and accepted community standards. So the head of a relevant entity must make a finding of reportable conduct if satisfied that the reportable allegation has been proved on the balance of probability. In deciding whether satisfied the case has been proved on the balance of probability, then matters can be taken into account which include the nature of the reportable allegation and any defence, and the gravity of the matter alleged. So the wording reflects considerations for assessing the civil standard as established in the Brigginshaw case and codified under Section 140, subsection 2 of the Evidence Act, as the threshold to be applied in considering and assessing the civil standard. So this means the head of a relevant agency has to establish that, more likely than not, the fact relied upon existed at the relevant time to make a sustained reportable conduct finding. This standard is met when the decision maker is satisfied or reasonably satisfied that the reportable conduct occurred. The determination is not purely mechanical or mathematical. So courts have provided guidance on how the civil standard is to be applied. And this process was established in a very old divorce case of 1938, which is Brigginshaw and Brigginshaw. And so, and again reflected in the Evidence Act. And so that requires consideration of the nature of the cause of action or defence, the nature of the subject matter, and the gravity of the allegations. So the High Court said, in a nutshell, the more serious the allegation, the more probative or stronger the evidence needs to be. It doesn't change the standard of proof that's required when dealing with more serious allegations. It simply means that a more rigorous approach to fact-finding is needed, and on the strength of the evidence necessary to establish a sustained finding on the balance of probability may vary according to the nature of what is sought to be proved. So the courts have confirmed this interpretation in Qantas Airways and Gamma. So if anybody wants that reference, it's going to be in, well, we can disseminate that. So if there's anybody really interested in that, we can send it around. But in that case, it said, the strength of the evidence necessary to establish a fact and issue on the balance of probabilities will vary according to the nature of what is sought to be proved. And I would add the circumstances in which it is to be proved. So guidance around the application of the civil standard is often misinterpreted to mean that reportable allegations cannot be sustained, or circumstantial or uncorroborated evidence. It can't be used, or it can't be used, or it can't be relied on. But circumstantial evidence can be relied on to sustain reportable allegations, but as long as it has sufficient probative value. So in this regard, a reportable allegation should not be sustained on a mere fact that it's suspicious, it's speculative, there's inexact proofs, or indefinite testimony, or indirect inferences. So the probative value of evidence is the extent to which the evidence can rationally affect the assessment on the probability of the existence of fact in issue. And again, this is all in a guide sheet, so a fact sheet, so you know, if you need any more information or guidance, it's available. So the wording was included in this to reflect the Brigginshaw standard, because the Department of Education raised concerns about confusion about whether or not sexual offences were held to the criminal or civil standard. This was also echoed by the Royal Commission into Institutional Responses to Child Sexual Abuse, because they recognised that the threshold wasn't recognised across the sector. They provided an example of this as Geelong Grammar School, and it showed the misconception about the threshold for reporting child sexual abuse matters. In that case, the former headmaster gave evidence that he would not report a complaint of child sexual abuse to the police unless he was satisfied beyond reasonable doubt that the allegations were true. The Royal Commission recognised that clarity about reporting thresholds is therefore closely linked to the institutional barrier of not having appropriate reporting policies and procedures in place. So the head of the relevant entity must take into consideration whether the reportable allegation relates to the conduct in breach of established standards applying to the employee, and they also have to consider professional standards, codes of conduct including professional or ethical codes, and accepted community standards.
Thanks, Alison. So moving on now, we're just going to look at some of the practical implications of the changes in reportable conduct for employers. So under the Act, the head of entity has to notify us within 7 days of being when and where that there's a reportable allegation or a reportable conviction. So that's been inserted to make sure that the notification is done as soon as possible and early, and any immediate risks can be identified and mitigated to ensure children are protected. The notification information which must be included is set out in the ledge, so I won't go through that now. And then there's a further obligation to provide a final report or update and an interim report, and that's within 30 days. Now, there are penalties attached to these for non-compliance, but those are not going to be effective for 3 months from commencement, so until the 1st of June. Question?
Sorry, it's hard to hear you.
Oh, okay. Yeah, big guns. I'll just yell a lot. Out of character. Hello. Oh, no.
Hello. All right, so then I think we can move on to the next slide, which was the single reporting requirements. So one of the initiatives of the Act is to streamline reporting requirements, and that's one of the biggest advantages in co-locating our esteemed reportable conduct colleagues with the other functions of the Office of the Children's Guardian, so that agencies will only be required to report once to us. So the current situation, as most of you would be aware, is that reportable conduct is reported to the Ombudsman, and then the Office of the Children's Guardian also receives information through the Working Children Check and also accreditation because of the condition in the accreditation of designated agencies that they have to report certain types of misconduct to the accreditation team. So from the 1st of March, the intention is that agencies will only need to report to one place, and that information will then be appropriately disseminated within our organisation according to protocols that are currently the subject of hard work led by Nicole Robinson. Is she in the room? Hi, Nicole. Moving on then to information sharing more generally, I mean, it's recognised that we are going to have a lot of information, and we recognise that data is going to be a key resource for us. And how we use it, how we can use it to benefit children, and how we can make it come to life is something crucial, which is the reason why we need to work out exactly what we hold, how we can use it, and where it needs to be shared between. So at the moment, of course, we receive information through a number of mechanisms, being Chapter 16A. Working Children Check receives the notifications of sustained findings. We also receive the notifications of concern from the Ombudsman. So since they're going to be brought into our fold, the reportable conduct team will be part of the Office of the Children's Guardian, then those notifications of concern will not come from the Ombudsman anymore, because it's not going to be external to us, it's going to be within us. And there's going to be a provision specifically about how that information has to be shared from the reportable conduct team into the Working Children Check. And so moving, I suppose, to the bigger picture of, like, we're not just interested in the individual allegations that come up. We want to be able to have an overall picture of how organisations are dealing with things that arise in their organisation. They are going to have systems and processes in place for dealing with allegations, and we can then audit those systems and seek further information. Another aspect is that agencies, of course, then need to have a code of conduct so that things that might not meet the definition of reportable conduct under the Act are still going to be addressed by another mechanism. So even though things might not fall readily into the definitions which we've now got in the Act, don't panic, they're still going to be addressed by the fact that, of course, all the agencies have rigorous codes of conduct that we can then audit and seek further information about. And over now to Paloma.
Oh yeah, I will need this.
Yeah.
So I'm going to talk about NCAT review. or complaints more generally. So because the reportable conduct scheme, I think, seeks to balance competing priorities of procedural fairness to a person who's the subject of an allegation with ensuring the protection of children and young people, administrative review and complaints and the ability to make complaints is particularly important. So under the Act, if a person has a complaint about the way that the Children's Guardian has oversighted an investigation, then they can make a complaint to the Ombudsman in their public administration jurisdiction. If a person wants to make a complaint about the way that an entity has handled an investigation, then they can make a complaint to us, to the Children's Guardian. And if a person is unhappy with the findings of the Children's Guardian's self-initiated investigation, so it has the same ability that the Ombudsman had to conduct an own motion investigation, that person or that employee can make an application to the tribunal for administrative review of the Children's Guardian's decision, because the Children's Guardian is an administrative decision maker. So it's the same as with the Working with Children check scheme. There's no requirement for internal review prior to making an application to NCAT. And if a person remains unhappy with the tribunal's decision, then they may have the ability to lodge an appeal with the Supreme Court, but only on points of law. So the next slide is about official community visitors. So the oversight and coordination of official community visitors for accommodation services for children and young people has been transferred from the Ombudsman to the Children's Guardian. So while the legislative basis for the OCV scheme is with the Children's Guardian, currently arrangements are it's being administered by the Ageing and Disability Commissioner, who also administers the official community visitor scheme for older people with disability. So accommodation services for older people with disability. And there's some arrangements in place, an MOU as to how that kind of practically works. Now the exciting things, timing. So it starts on the 1st of March 2020, and that is with the exception of a few provisions. So provisions from the Care Act that never actually commenced, so they were never operative. So they relate to removal of responsibility for daily care and control from authorised carers and applications for review of orders by the Children's Court. They don't commence on the 1st of March. And I think, as Alison mentioned, in respect of reportable conduct, providers of overnight camps, accommodation and respite services for children that provide overnight beds for kids, including housing and homelessness services, and providers of family group homes won't be brought within the reportable conduct scheme on the 1st of March. And so I think some further consultation is required for those groups, and they'll be phased in at a later date. So another exciting thing is that people have some time to get their act together, and the Act delays the application of some of the penalty provisions for non-compliance. So the following enforcement provisions don't actually commence until the 1st of June 2020. So I think Andrea alluded to those. There's failure to notify within 7 days after becoming aware of the report without a reasonable excuse doesn't commence or doesn't attract a penalty until the 1st of June. So organisations can figure out their processes and procedures. Failure to prepare a report for the Children's Guardian doesn't commence until the 1st of June. The penalty provision and disclosure of relevant information relating to a reportable allegation or conviction without lawful authority doesn't attract a penalty until the 1st of June. So we're also in the process of making some regulations under the Act. So while the Act sets out the key provisions, it needs accompanying regulations to set up the detail. So the current regulations under the Care Act, the Adoption Act and the Ombudsman Act will continue as is. And where one of the key differences with the regulation that will commence later in the year is that it will establish a residential care workers register, which was another recommendation of the Royal Commission, and we'll give you some more information about that at a later stage as well. And then there'll also be transitional regulations which will commence on the 1st of March, and those transitional regulations will preserve existing class or kind agreements that were made under the Ombudsman Act. They'll preserve the Children's Employment Authorities and exemptions that were made under the Care Act. And they'll provide that existing designated agencies that arrange the provision of statutory and supported out-of-home care under the Care Act are taken to be designated agencies that arrange for the supervision, for the provision of statutory and supported out-of-home care under the Children's Guardian Act. So the transitional provisions arrange for the continuation of things as normal, I suppose. So another regulatory amendment that we're making is to the Working with Children check regulation. Records Review will be aware that currently we receive notifications of concern from the Ombudsman and also reports of sustained findings of misconduct. So a regulatory amendment will be progressed, the effect of which is to ensure that these reports come to the Children's Guardian directly and that they'll be directed to the appropriate place. Also, another important thing, just add this in, is that there's a review provision in the Act. So under Section 183, the Minister has to review the Act within 2 years of commencement to ensure that it's working okay. So that'll give an opportunity to really reflect on how the provisions are working and make any necessary changes.
So that's the Children's Guardians Act nutshell version. We've prepared FAQs and we're continuing to, we had one open door session last week, I think, and we'll have another next week. We welcome questions from you in terms of, detailed issues that you want to know about, and we'll prepare scripts and FAQs and things so that once it all starts rolling out, you will have the scripts for what you need to answer. Overall, I think the one thing that we need to bear in mind is that while the legislation has been really carefully crafted and by reference to the Royal Commission's recommendations and the experience of other jurisdictions, it will require fine-tuning along the way, and as Paloma said, there's a 2-year review, but even in the interim there might be things that we need to amend. So if things don't work or if there's a major issue, it's not the end of the world. And I would really encourage us all to step into this new era together, and with a sense of, with an open mind and a sense of excitement, because I think this is really a new start, a new chapter in the life of the Children's Guardian. And I think as long as we keep in mind the OCG's vision, which is to create safe places for children, as long as we keep in mind the OCG's actual role, which is as a regulator and as an administrative decision maker. And I think the key to success in this whole thing is how we manage the holdings of information that we're going to be having, the appropriate use of information. I think we will be on a good path ahead. So we're very excited about the commencement on the 1st of March. I know that some people may be a little bit anxious, and I can totally understand, particularly the report of conduct area, because there's been changes, stakeholders are affected. But I think that with everything else that is new, there's always a sense of anxiety, but I think it will all work out, and legal services are there to provide support, not just up until the 1st of March, but on an ongoing basis. So if there are questions, if there are suggestions, whatever it is, if you want to talk something through, please feel free to contact us, ideally through the legal inbox, and then we can think it over and talk to you about it. But thank you all. Thanks.
Question.
Yes.
The conduct that's reportable, presumably it includes historical conduct. So who would do the investigation? The current employer
Yes.
or the employer?
The current employee. So how it works is that historical conduct only comes into play if the current employer becomes aware of it whilst the employer is in that person's employment. So then it's the current employer that would conduct the investigation. It doesn't track back.
Can the children's guardian though instruct, so say that like a private school, say the person now works for Westminster School but they want to work for Knox, and so can the children's guardian say, well, we also want Knox to do an investigation as well? Can they do that?
The children's guardian would have the power to do that, but generally speaking in the legislation we've sort of said we also have the capacity to be able to say, to exclude an agency from doing an investigation because we don't want to have 3 different investigations running at the same time. So there is a provision there that says that if we have been made aware that this person has been working in 3 different places, we could exclude other people, exempt other agencies from conducting an investigation and just concentrate on whichever one, the latest of the one who's made the allegation. Sorry, report of the allegation.
Okay.
But they would be encouraged to share information.
Oh, yes.
So the other agencies conduct their own risk assessment to make sure that that employee.
Absolutely, that's actually included in the provision that the other agency must still do its own risk mitigation and all of that. They just don't need to necessarily conduct an investigation. The historical aspect of it came from the Royal Commission, so how much of that will play out will be sort of left to be seen, but it's been specifically mentioned in the Royal Commission report. Any questions? Any other questions? Quick ones? Well, if you think of any others, please do feel free to talk to us. We may not necessarily have all the answers, but we'll do our best to understand the context and explain the policy behind it. Thank you so much.